In the late 1960s, President Lyndon B. Johnson was leading a nation immersed in two major battles. At one end, the Vietnam War was in its official second decade. LBJ was escalating the U.S. offensive there. And back home, civil rights achievements were being met with intense pushback from segregationists and white supremacists. In just the summer of 1967, there were more than 100 race riots, leaving dozens dead and thousands injured, making it clear the movement for racial justice had a long way to go. One of the most consequential weeks that summer was in the middle of June. On the 11th, a huge race riot broke out in Tampa, Florida. The next day, the Supreme Court issued a landmark ruling that said bans on interracial marriages were unconstitutional. And then on June the 13th, 1967, President Johnson made an historic and very timely announcement.
I have just talked to the Chief Justice and informed him that I shall send to the Senate this afternoon the nomination of Mr. Thurgood Marshall, Solicitor General, to the position of Associate Justice, Supreme Court, made vacant by the resignation of Justice Tom C. Clark of Texas.
By that point, Thurgood Marshall was not a stranger to the Supreme Court. As a top lawyer for the NAACP, he had pushed the court to declare public school segregation unconstitutional. That case was Brown v. the Board of Education. Marshall's talents caught the eyes of two U.S. presidents. John F. Kennedy put him on the Second Circuit Court of Appeals, and 4 years later, LBJ made Marshall the U.S. Solicitor General. So by 1967, Marshall was more than qualified to sit on the Supreme Court. But at the tail end of the civil rights movement, segregationists, the old guard, almost all of them Democrats back then, didn't want to see the political tide turning in that direction. And they tried to use the tensions in the summer of 1967, the race riots, the rising crime rates, to undercut Marshall's chances of confirmation. When his Supreme Court hearings in the Senate came around, some Southern senators looked for ways to trip Marshall up. Strom Thurmond, in particular, kept asking questions that were like trivia questions, Supreme Court scholar Carolyn Shapiro recalls. Questions like, tell us the names of the people on the committee that voted out the 14th Amendment. Ridiculous question. The 14th Amendment, which had passed a century earlier. Marshall was even pushed to affirm his loyalty to the United States.
Based upon the questions propounded by Senator Javits, and I ask you again, is there anything you can think of in your mind or in your disposition to prevent you from acting fairly, effectively, and efficiently for the United States government in this position?
Not at all, sir. I believe that, well, I'm certain that there's no possible reason that I could have to not adequately represent this government, which is, after all, my government, just as it is all of our government.
Southern segregationists on the Judiciary Committee, like Sam Ervin of North Carolina, tried to brand him a judicial activist. And even the media was amplifying some rather bigoted tropes against the first black Supreme Court nominee. As journalist Juan Williams recalled in his book on Thurgood Marshall, quote, the Chicago Sun-Times wrote that lawyers would be keeping an eye on Marshall because he had been subject to criticism for laziness. Joseph Kraft, the preeminent Washington columnist, wrote Marshall's only qualification was that he was a Negro, not just any Negro, but not even the best qualified Negro. According to Williams, those racist tropes were enough to make LBJ have doubts about the nomination. Williams writes that the president wondered, was he really a good lawyer? And what about talk that Marshall was lazy? Imagine being a hugely successful attorney, becoming a federal appeals court judge, then becoming Solicitor General of the United States of America as a black man, beating all the odds. And people, including the president, thinking you're lazy. We all know what this is. Racism. Plain and simple, racism. Marshall was, thankfully, eventually confirmed. The first black man on the Supreme Court almost 180 years after its creation. Now, you might think that 55 years later, those kinds of racist tropes and bigoted arguments wouldn't have any place in a Senate confirmation hearing for a black nominee today, a black female nominee, the first in American history. Well, hold that thought. Because today the Supreme Court hearings began to confirm Judge Ketanji Brown Jackson, Joe Biden's own historic and timely nominee for the highest court in the land. Republicans in the run-up to these hearings had already done a song and dance about the experience and the qualifications of this eminently experienced and eminently qualified judge, Harvard law grad and former SCOTUS clerk. But Senator Ted Cruz wanted to assure us
it's not about race. We will see Democrats in the media suggest that any senator that is skeptical of your nomination, that questions you vigorously, or that dares to vote against you must somehow harbor racial animus. So this is not about race.
You know what they say, if you have to say it. Just a couple of hours later, in fact, his Republican colleague, Marsha Blackburn, had this to add.
You once wrote that every judge has, and I quote, personal hidden agendas, end quote, then influence how they decide cases. So I can only wonder, what's your hidden agenda? Is it to let violent criminals, cop killers, and child predators back to the streets? You have praised the 1619 Project, which argues the U.S. is a fundamentally racist country, and you have made clear that you believe judges must consider critical race theory when deciding how to sentence criminal defendants. Is it your personal hidden agenda to incorporate critical race theory into our legal system?
1619, critical race theory. Personal hidden agendas. Just count those racist dog whistles. The questioning of Judge Jackson by members of the Senate Judiciary Committee could get pretty ugly this week. Republicans aren't hiding what they're doing here, by the way. Earlier this month, Senate Minority Leader Mitch McConnell pulled from the old anti-Marshall playbook too, citing a rise in crime rates to say Jackson would go soft on crime. And just like the media back then, people like Tucker Carlson on Fox today are questioning her qualifications, asking to see her LSAT scores from 25 years ago. When was the last time we saw Neil Gorsuch or Brett Kavanaugh's LSAT scores? Early in his career, when he was fighting cases against segregation across America, Thurgood Marshall said he knew America's struggle with race, specifically with racial justice and prejudice against black Americans. He said he knew it took time.
Maybe you can't override prejudice overnight, but the Emancipation Proclamation was issued in 1863, 90-odd years ago. I believe in gradualism. I also believe that 90-odd years is pretty gradual.
It's 2022 and America still has not had a black woman on the Supreme Court. I mean, even if you believe in gradualism, I think we can agree that this particular milestone is long, long overdue. And despite some Senate Republicans on the Judiciary Committee today seeming to dip into the Southern segregationist playbook from the late 1960s, Judge Jackson handled day one with grace.
During this hearing, I hope that you will see how much I love our country and the Constitution and the rights that make us free. I stand on the shoulders of so many who have come before me, including Judge Constance Baker Motley, who was the first African-American woman to be appointed to the federal bench and with whom I share a birthday. And like Judge Motley, I have dedicated my career to ensuring that the words engraved on the front of the Supreme Court building, equal justice under law, are a reality and not just an ideal.
Hi, I'm Mehdi Hasan. Thanks for checking out our channel on YouTube. You can see more of the Mehdi Hasan Show by clicking on any of the videos on this screen, and make sure you subscribe below to stay up to date on the day's biggest stories. Thank you for watching.